So periodically I come across these videos talking craziness about me. So let's see what this is the Madcaster. Let's see what he has to say. I'm sure it's not going to be anything worth value, but nevertheless, here we go.
Hey there, I'm the Madcaster. Am I glad to see you here? Well, you thought we were done with the TikTok psychic? Wouldn't you know, right after I made my last video about her, there's another motion that she filed. It's got to be getting the judge pretty annoyed. We're going to talk about it right now. You know me, I've got the deets and all the receipts, so buckle up and let's go.
I don't want to hear your intro. It is irrelevant to me.
60B2 motion for reconsideration of
Let's see.
60B2 motion for reconsideration of partial summary judgment. And it says, now comes the defendant Ashley Guillard, respectfully moves the court for relief from order granting partial summary judgment. Pursuant to Rule 60B, grounds for relief from final order or proceeding on motion in just terms, the court may relieve a party or its legal representative from a final judgment, order, or proceeding for the following reason. Newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial under 59B. What new information? The documents and evidence provided by state court trial in State of Idaho versus Brian Koberger. That's the guy who is actually the culprit who was arrested and is now.
So that's where I have to stop him. A lot of these people, some of these people doing reaction videos or talking about me on their YouTube channels, TikToks, social media, whatever, are not American. Maybe a few of them are not American, but I don't know if he is, but I think he is. With that being said, in America, just because you're arrested doesn't mean that you're guilty. Just because the police believe you to be whatever, committed whatever crime, doesn't mean that you committed it. In America, we are supposed to presume innocence until proven guilty in the court of law. We're not even talking about the court of public opinion. We're talking about the court of law. So for him to be referring to Brian Koberger as the actual culprit, well, that's how you know his video is starting off with a lie. A lot of these people, when they do videos about me, they just lie. Like most of what comes out of their mouths is a lie. So Brian Koberger was arrested. Yes, Brian Koberger was charged with quadruple homicide and burglary. But he has not been found guilty. And to be honest, it's not even a lot of evidence proving that he is guilty, or even enough evidence to prove that he committed any of the homicides.
Going to be tried. And it just says that provides factual support that substantiates the TikTok videos Guillard posted regarding the deaths of the 4 University of Idaho students. With the newly discovered evidence, Guillard cannot legally be found liable for defamation because the evidence proves that she was 1, telling the truth in many of the videos, and 2, not proven to be false in others. Pursuant to the Supreme Court, truth is an absolute defense against defamation. I don't know what the heck she thinks is going to be brought up in that trial that's going to help her. It's certainly not going to involve the professor. Additionally,
Okay, so first of all, he don't know the professor from a can of paint. So for him to be making statements about what she did and did not do, or was and was not involved in, again, that's just a blatant lie. It's just ignorance, and it's not a fact. Second of all, of course, there are going to be things that come out in the criminal case that could substantiate the things that I've said, because the two cases are connected. My statements were regarding the murder of the 4 University of Idaho students. There's a criminal case going on with that. The state of Idaho versus Brian Koberger, and the civil case Schofield versus Guillard is also, again, related to that, because my statements were about the who, what, when, where, and why the University of Idaho students were murdered. So for him to act like, and then from an outside perspective, anything that come out in that court could help me. It could also prove that it could prove that I'm telling the truth, and it can also debunk what I'm saying. So for him to act like, oh my God, there's no connection, he might just be stupid too. I don't know.
there are outstanding issues of material facts. Therefore, the court bound by the parameters of the law, and glad she's lecturing the court on the law, is legally.
I'm not lecturing the court on the law, but when you file documents, you have to have a law to back up what you're saying. So he's just criticizing, he's just chatting at this point.
Required to reconsider the order granting summary judgment and subsequently deny the plaintiff's motion for partial summary judgment and deny the plaintiff's motion to add punitive damages. The court wouldn't go back now and deny the motions it's already granted. So, I mean, this is problematic for many reasons. And
okay, that's what a motion for consideration is for. You know what? I think on another one of his videos, he may have alluded to being an attorney. If he's an attorney, there's a reason why he's doing YouTube videos and he's not in court. There's a reason why he's doing reaction or he's reading my court documents as a pro se litigant and not his own. Because one, mine are more interesting, and two, obviously he doesn't have work like that because he's not very good at what he does. Filing a 60B2 motion for reconsideration based on new evidence is just law. It is granted by federal law. It is permitted by federal law. So it's not crazy. If he thinks the law is crazy, that's one thing. But I didn't make this law. I didn't make this rule. So therefore, I'm just utilizing a rule that is at my disposal when it pertains to when I have evidence to support my motion.
You guys know that this is just more gamesmanship on her part. If you've ever wondered how scammers get your phone number or why your email inbox is always...
I should care considering someone is stalking me. I pretty much know who it is, but this isn't going to help me with the stalker. I don't want to hear his ad.
Random here that she's filed in support of her motion. As supported by law, defendant Ashley Guillard respectfully moves the court for relief from the order granting partial summary judgment. Newly received evidence derived from credible sources establishes beyond dispute that Gillard's TikTok videos regarding Schofield and the deaths of the 4 University of Idaho students in Moscow, Idaho are substantially true. And again, there can't possibly be anything. I'm going to go look and see what's going on with this guy's case, but there can't be anything. The professor is no way involved, way, shape, or form in this.
Here he goes lying again. He does not know her. He does not know if she's involved. He has not been presented with any evidence to say that she has not been involved. She has not presented any evidence other than words. She said she's not involved. Everybody's like, okay, she's not involved. She said she's not involved. It's called that's hearsay. It's nothing to support what he's saying right now. So basically he's just saying anything.
It's mess. And
he's speaking like he knows, like he's speaking like it's a fact. I find that to be very weird because he does not have any evidence or facts to back up what he's saying. And we're talking about a quadruple homicide. So he's just basically saying anything regardless of what it's about. It's weird.
I don't know what she thinks is there, but I'm guessing she's probably going to tell us in a minute. So I'm not going to repeat all this. She just said it in her motion about all the outstanding issues, etc. So let's move on. I'm not going to go through all the background because you guys know the whole story about the students and how she's wrongly implicated this professor who,
again, making statements that he cannot back up. He does not know if she did it or not. So he cannot say for a fact that I wrongly accused anyone.
I'm sure, sick and tired of the publicity that she never asked for.
And then to say that the professor is, Schofield is tired of the publicity that quote unquote she didn't ask for. Yes, she did. My videos were on TikTok and not even my full audience probably saw it because the way TikTok algorithm works, sometimes your followers see it or whatever they're called on TikTok, and sometimes they don't. But they took it beyond TikTok. They sent press releases to, what did they send a press release to? several different places. I want to say I had emails from Good Morning America. There is a freaking documentary on Hulu. There is NBC, all type of news networks, TMZ, Entertainment. So many different outlets, media outlets that they sent this story to regarding the case. They wanted the publicity. They did that. I didn't send any press releases out. They did. So they turned an issue that was on social media, TikTok specifically, and spreaded it all across, I want to say, even the world. BBC was contacting me in Europe. So they spread it across the world. And additionally, they filed a lawsuit as well. So she's getting the publicity because she wanted it. I didn't file the lawsuit. I didn't submit the press release. She did, and her attorneys.
Didn't deserve because it's beyond doubt that she was not involved in.
And that's not true either. She has presented no evidence, no concrete evidence that beyond a doubt she's not involved. She's only submitted documents and words from, we'll get there.
Anyway, she didn't even know these kids. So
He does not know who she know. All he knows is that she said she don't know them.
anyways, let's just cover what she thinks is this new information. And she says that on June 6, 2024, the court granted the plaintiff's amended motion for partial summary judgment and the plaintiff's motion for leave to amend the complaint to add punitive damages. And the court has given all of its reasoning and all of the other decisions about why it did so. There's nothing that's going to change that. On June 13, 2024, the defendant rescinded the consent to proceed with.
So that's why we're here, because the court granted her motion to amend the complaint to add punitive damages and her motion for a partial summary judgment. My issue when I submitted the Rule 59 request for reconsideration or request for a new trial is that she hasn't presented any evidence that I made a false statement knowing that it was false. But the court, throughout this entire litigation, throughout this entire case, has treated claircognizance as if it wasn't real or plausible, treated psychic abilities as it wasn't plausible, treated tarot cards and oracle card readings as if they weren't plausible to be able to provide valuable information. So basically, ignorance. So far, I've had to fight against ignorance, not only of Schofield and her attorneys, but also from the court. Because again, they made statements or they had the idea or the thoughts or lack thereof that claircognizance isn't real. And it is. So the purpose of this 60B2 motion is to show the connection of the evidence in the criminal case of the state of Idaho versus Brian Koberger, that has been presented so far, because obviously a lot of the evidence has not been presented, and connected to the things that I've said. And once I've looked at the evidence, the text messages from the roommates, the 911 call, the DNA evidence, it has proven that a lot of the things that I said in my videos are true. So if I have the ability, if I can prove that my abilities, my claircognizant abilities are authentic, the court can then no longer say, because I have evidence support that it is real, that claircognizance, oracle card readings, tarot card readings, clairvoyance, whatever, is implausible. Because if I have proof that I've made predictions or I made statements regarding intuitive statements regarding what I believe to have occurred the night of the murders, and I have evidence to back that what I said was true, the court can no longer disregard my statements as implausible. And because they disregarded my statements as implausible, they also made accusations of me of me being malicious. For example, the court said that because I did not listen to the police, that that showed, in his opinion, malice. But we're in America. We don't have to just take the word of the police. We're allowed to have our own opinions. We're allowed to, in fact, it is civil for us to not just simply believe the police and prosecution. It is civil for us to look at both sides. It is civil for us to look at both sides of the fence, the defense and also the prosecution, and make our own judgment calls based on that. In fact, that's what the Constitution asks us to do. Innocent until proven guilty. That's called due process. That's what due process is. So for the judge to infer that I did not, by me not listening or taking the narrative of the police, which came out after the lawsuit was filed, keep that in mind, that I was being malicious and that just wasn't right. So now in this motion, I have proof that what I was saying was true when I said it, and I said it before anything came out to support what I said. My predictions were accurate, and the stuff that the police were putting out were not accurate. For example, when the police, Moscow Police Department, put out that the roommates did not hear anything the night of the murders and were sleeping, and that wasn't accurate. I put out that's not true at all. They did hear, and basically, what I put in this motion is that I predicted even the conversation. I said they didn't want to be alone. They mentioned that in their text conversation. I said they took refuge together. They mentioned that in their conversation. I said that, and they did that based on the evidence that's presented in Koberger's trial. I said that I said the roommates saw Zana or heard Zana crying. They have that in the evidence as well. I said they felt like they had to take a risk. And that's why in the text messages, DM was saying something like she was freaking out. And because now I don't know, and I still don't know, but I'm kind of alluding to, I'm kind of inferring it from the court documents. DM's room may have been on the same level as Zana's. Granted, I knew nothing and know nothing really about these students or their homes. I have not researched floor plans or anything like that. So when I was posting my videos and I said DMs or the roommate saw Zana the evening of the murders, and that she had to take a risk based on the route for her to get to the room to take refuge with BF, I didn't know that her and Zana were on the same level. So I was just channeling what I channeled, or putting out what I received through claircognizance. And again, the evidence is supporting it based on what they have.
For a magistrate. And in my last video, we talked about the court ruled that it was too late. You can't give your consent and then you don't like the outcome of what's going on. And so you're going to revoke your consent. That's not how it works. You don't get a do-over because you don't like what happened. Right. And we know all of this. So I'm going to skip this part. So the legal standard, we don't have to go through. We've talked about this in several of her motions. Let's just go over the argument. Now, this is where she's going to say.
Okay, so I'm going to talk about the legal standard before he gets into the argument. The legal standard for a person or plaintiff to win a defamation case, the plaintiff has to prove that the defendant made a false statement knowing it was false. Those are the two elements that I focus on this motion because, again, I have not made a false statement knowing it was false. If I made any false, in fact, none of the statements that I made have proven to be false. So I'm proving to the court, one, claircognizance is plausible. I have the ability to get answers, even though I was not there, don't know them, did not see it with my own physical eyes. I saw it with my third eye. That's what people call it, the third eye or claircognizance. And I was able to discern from there. And it's plausible. It's not fantastical thinking like the court has called it, or implausible like the court has called it before. So this is the point of my motion, to show, based on the evidence in the criminal case that has come out so far and my videos, that a lot of them have already proven to be false. And as time goes by, more and more of true, Jesus Christ. A lot of them have been proven to be true. And as time goes by, more and more of them are also being proven to be true. For example, the other day, There was another court document filed after I've already filed these motions. After I filed this motion and a response and the reply, that the roommates admit that they all gathered together after they got back from the several parties that they were attending or wherever they were prior to. And I also mentioned that in one of my videos as well. He's going to try to make it seem like nothing I said was of value, but let's keep going.
But she believes this incredible new evidence is that's going to exonerate her. Argument A, newly discovered evidence supports that Guillard's videos are the absolute and substantial truth. On December 9th, 2022, Guillard posted a video that the surviving roommates of the homicides were afraid the night of the murders and decided to take refuge together so they won't be alone. Guillard also stated the roommates adapted to the circumstances to the best of their ability instead of trying to change the circumstances. What the heck does that mean? They waited together until they came to rescue them, led out of difficulty, and kept them safe. On February 24th, the state of Idaho filed a motion to admit the text messages of these survivors regarding their conversations with each other. On November 13, 2022, the motion included an excerpt from one of their iPhones. The text dialogue between the roommates reveals that the early morning hours, the surviving roommates were freaking out. One told the other, come to my room, and to run. One sent a text to the other at 4:25 a.m. saying it's better than being alone. After a waiting period of about 6 hours, one of them began reaching out to the victims and others. The motion to admit text messages of DM this person, and the 911 call reveals that within 8 hours, the surviving roommates were rescued by their friends, HJ and EA. They both came to the scene, located the body of one of the victims, instructed the surviving roommates to call 911 and help them. Guillard's video statements regarding the roommates' activities the night of the homicides matches the state's evidence. Okay, so the whole part that she's missing here is, first of all, I don't know whether she picked this from a news story.
And that's how I also know that he hasn't been paying attention, because everybody who's been paying attention from the beginning know that the police made a statement that the roommates were sleeping. So they know that this information was not put out until later. But initially, they tried to make it seem like they heard nothing and that they were sleeping. So there was no article out for me to go, and if it was one, I didn't know about it. But there was no article for someone outside of Idaho to go find and get information about what the roommates were doing the night of the murders.
Before she made her videos, because I'm sure there was information out there, but even if coincidentally,
that's not a coincidence.
She was right about the survivors being afraid and trying to protect themselves.
And don't try to minimize it to me just saying they were afraid and try to protect themselves. Because, like, no. They said specifically, come together so they won't be alone. In the text messages, it's proof. The state's evidence. In my video, I said they decided to come together and take refuge together so they won't be alone. And the reason why I mentioned the fear is because a risk, in my video, I said a risk had to be taken. And a risk did have to be taken, because I didn't realize, again, that DM had to pass Zana to get to BF. Also, at that point, she claims to have saw a masked man. So she had to determine which route to take, because he was allegedly outside. She says she saw him go outside. So she's not going to go outside because she saw a masked man go out there. So she has to find a way to BF where they can hide together, because, again, she said she saw a masked man go outside. Who's going to go outside when they think someone with a mask on is out there that can hurt them? So anyway, the fear was me just pointing that out. There was a risk that had to be taken. Of course, they're going to be afraid, but the police didn't say any of that. They said they were sleeping at this time. So for him to try to make it like a coincidence, no, it wasn't. Because guess what? They could have been asleep.
First of all, that kind of seems like common sense, like the reaction you would have, right?
And it's not common sense, again, because they could have been asleep.
What does this have to do with her accusing the professor? Even if part of what she said might be true or is based on facts that were put out there, that has nothing to do with the fact that she defamed the professor by accusing her of doing this.
Yes, it does. And I'll get to that. We'll continue. It does because, again, their entire argument, this entire case, was that I made a false statement, knowing that it was false. Their entire argument was that I made these false statements for clout and money. They have not proved any of those things, clout nor money. Nor have they proven I made a false statement. Nor have they proven that it was intentionally false. So what he's trying to do is say, okay, what you said may be right about the roommates, but what you said, what does that have to do with what you said about the professor? So what he's trying to do is put the burden of, excuse me, he's trying to put prosecutorial burden on me as a defendant in a civil case for defamation. What he's ignorantly trying to do is say, she has to prove the state's, as if I'm the state. He's making it like I have to prove a criminal case in order to win this civil case against defamation. That's where he's a bit ignorant. He's thinking that I have to be the states, I have to be the detectives, I have to be the prosecution and prove that Schofield ordered the murder of the 4 University of Idaho students in order for me to win a civil defamation case. And that's where he's just plain dumb. And if he's anybody's attorney or lawyer, whatever, I feel sorry for them. I don't have to do that. All I have to prove is I did not make a false statement and really it's or, because you have to meet all elements of a defamation claim. I did not make a false statement, and I did not make a false statement knowing that it was false, and she didn't suffer any damages. And she didn't suffer any actual damages, as the state of Idaho requires.
It has nothing to do with the other facts. That's not how you exonerate yourself from defamation. These are just extraneous facts to the case, the civil case. On November 30th, the Moscow Police Department issued a press release updating the public on the known facts surrounding their deaths. The statement claimed 2 surviving roommates did not wake up until later that morning. Guillard's psychic investigation
also
promulgated on TikTok.
That I mentioned that the Moscow PD issued a press release on the known facts regarding the homicide, and that they stated that the surviving roommates did not wake up until that morning. I have to mention that because, again, the judge made it seem like it was malice for me not to take the word of the police officers over my own. Again, that's not required of any American, one, and it does not show malice anyway. But additionally, if I have evidence to support the things that I'm saying, then it is not illogical for me to have not listened to, or it's not malice or illogical for me to not have listened to the statement that the police put out, because it turns out to be false. Hindsight. It turns out that what they said was false and what I said was true. That's not malice. Telling the truth is not malice. Not believing a lie is not malice.
TikTok on November 30th, 2022, and December. Okay, so her first psychic investigation was the day the police department made the statement about the survivors and what was going on at the scene of the crime. And then she puts out a video, and we're supposed to think, oh, she didn't hear that. This was all based on her tarot cards.
Yeah, he does not know the case. So he's creating an alternate, he's lying. Let me just not say it in a pretty way. He's lying, and he does not know what he's talking about. He's just talking, he's chatting. He's basically saying that I got my information off the police statement and tried to say it was like claircognizance. But the police, again, did not issue that statement at that time.
An intuition? Come on. And December 9, 2022, discerned that the surviving roommates were not sleeping, heard everything, and that they had an understanding that something dangerous was occurring. You think? DM's iPhone extraction also confirms that Guillard's psychic investigation was correct. The surviving roommates were not sleeping and heard the commotion of the homicides. Gillard's video statement regarding the quadruple homicide matches the state of Idaho's evidence. Again, irrelevant to what the defamation case is about.
Not irrelevant.
On December 13th, 2022, Guillard conducted a psychic investigation regarding the white Elantra that Moscow PD suspected was connected to the deaths. She posted the results on TikTok on December 13th and December 14th. Guillard stated on the video that Rebecca Schofield had access to a white Hyundai Elantra the night of the murders, and that she drove to the scene of the homicides to ensure the execution of the murders. On January 12th, 2024, Rebecca Schofield admitted to having access to a white Hyundai Elantra. I wonder how many of those there are in the world.
How ironic for him to say that. Again, additional proof that he is not connected at all. He does not know what's going on with this case. The states, and most of the states and these people who believe Koberger to be guilty, most of their arguments relies upon this white Elantra and that he has one. They have no plates. They have no other identifying factors. In fact, the year of his vehicle is not initially the year of the vehicle that they were initially looking for. Remember, they were looking for 21 to 2013. His vehicle is what, 2016, 2014, and 2016. So they changed their range of the year of the vehicle after the fact. But anyway, he must not be very aware of this case because he would know that they did not have a plate or anything.
Maybe if she had given a license plate number, that maybe would have been a little more convincing.
Why would I have to do that if the police are not even doing that? They have a whole criminal capital murder case. And guess what? They don't have license plates. So if you want to say there's 20,000 vehicles that are white Elantras, tell that to the prosecutor, the state of Idaho.
But white Hyundai Elantra, I must see a dozen of those every day when I'm commuting for court. The state's Exhibit A alleges evidence that a white Elantra was seen near the area of the homicide several times. On February 24, 2025, Brian Koberger's attorney filed a motion regarding the make and model of the suspect's vehicle. So this is the suspect's vehicle. Now, if it's registered to him, that's going to be totally flying in the face of what she's trying to allege here. The motion
they have not proven registration.
Introduces the possibility of two separate white Elantra. Gillard's video regarding the white Elantra connection to the quadruple homicides matches the evidence presented. Gillard's video stating Schofield had access to a white Elantra the night of the quadruple homicides is accurate. Schofield admitted to having access to a white Elantra the night of the quadruple homicides. Now, what's really interesting, I don't know if that's true. I haven't heard that.
So, again, in the admissions, the request for admissions to me that they sent me, they asked me, what did they say? They said, admit you did not know about the white Elantra until the police mentioned they were looking for a white Elantra. I'm like, okay, like, and was I supposed to know everything? And my point was, if she did not have access to a white Elantra, why say that? It's like, oh, she only knew because the police knew. Why not just say, Schofield did not have access to a white Elantra? And the defendant Guillard claimed that Schofield had access to a white Elantra the night of the murders. They didn't say that. They said, admit you didn't say it until after the police said it, which who cares? They mentioned they were looking for a vehicle. I did a reading on the vehicle. Like, who cares? Additionally, after I filed this motion, their response was they didn't say it for that. They said it because they were trying to get me to admit that I didn't say it until after the police said it regarding the white Elantra. And then went on to say, Guillard does not have evidence that Schofield had access to a white Elantra the night of the murders. Why not just say Schofield did not have access to a white Elantra the night of the murders? Still haven't admitted that what I said was false. Only admitted, only said that I don't have evidence. Well, I don't have any of this criminal evidence because it's being sealed. It is a criminal case. It's not my case. And when I tried to get my own evidence, the court, I issued a subpoena to Meta Platforms. Meta Platforms did not immediately respond to the subpoena, quoting some law. Months and months later, Meta Platforms emailed me and said they were waiting to hear from the judge because Schofield and her attorneys filed a motion to quash my subpoena to Meta Platforms because they said baby pictures could be compromised. Okay, we're talking about a quadruple homicide and me getting evidence of her connection to it. And they were more worried about baby pictures. The court took the bait and granted their motion to quash the subpoena that I issued to Meta Platforms and ordered Meta Platforms not to comply with my subpoena to protect the baby picture.
She doesn't cite to anything. So what? We're supposed to take her word that she said this? What is she citing to? She needs to put a citation in a quote.
The evidence.
You can't just say she admitted to it. When, how, what did she say? What was the context?
It was in the docket. He's not paying attention. He's not a very good lawyer.
Of that conversation. On November 25th, 2022, Guillard posted a TikTok stating that the dog Murphy was around but separated from the victims and that the dog was fed to keep quiet. On December 29, 2022, acting peace officer within the county of Lada, state of Idaho, filed a sworn statement. The statement reveals that police body cam footage shows the dog Murphy was around but separate from the victims. He was in KG's room. Gillard's video statement matches the evidence presented in the homicide case. November 23rd.
And that may seem small, but it's not because it all adds up. Murphy could have been with the victims. Murphy could have been outside. Murphy could have been full of blood. Murphy could have been gone. But I was correct. He was in the home, but separated from the victims. Come to find out, he was in KG's room, and KG was not in her room. She was in the room with Maddie.
2022 and December 9, 2022, Guillard posted 4 TikTok videos stating that the University of Idaho killer was broken up with by victim KG on January 13, 2023. Okay, so wait a minute. Didn't she try to say before, if I recall, that this guy was hired by the professor to do this job and it was like this hired hit? Well, this guy who is the suspect was the ex-boyfriend of one of the victims. That totally doesn't jibe with what she's saying about the professor hiring this kid.
What? Can he even talk? No. That I did say, I said that it was, she hired one of 2 students, but one of 2 students to execute the murders of the 4 students. Initially, starting with one, hiring another one, choosing another one to do the crime. I also said that the person that she hired was KG's ex-boyfriend, that they had broken up. Come to find out, 3 weeks before, or approximately 3 weeks before this happened, KG did go through a breakup, and she did have an ex-boyfriend who was in close proximity to the home, who had joint responsibility or had the dog with her, who she was leaving the dog, her and the dog were leaving the next day. She was about to take the dog. What else? His alibi was sleeping. Also, additionally, his friend was in it seemed like a heated or passionate, not really heated, passionate discussion. They have videos of him and Kaylee and Maddie speaking with her ex's best friend, alleged best friend, the night of the murders as well. Additionally, he was with them the night of the murders. So it's a lot of things connecting him to this as well. For them to have said cleared him is another story, but yes, she had broken up. She had went through a breakup.
Again, if I recall correctly, she never said that this guy was the ex-boyfriend of one of these kids. There are outstanding issues of material facts. Guillard's statement has not been proven to be false. On November 29, 2022 and December 9th, Guillard posted a TikTok video stating the victims were separated in 2 different rooms. Wow, that must have really taken a lot of thinking to come up with that guess in a house. Just
see, he is lying again. So if I was correct in stating that 2 of the victims were in one room, EC and XK. 2 of the victims were in another room, MM and KG, and the roommates were together in another room. 2, 2, 2. They were all in their rooms. They could have all been in the kitchen. They could have all been unalived in the kitchen. They could have all been murdered in KG room. They could have all been murdered in the living room, in the bathroom, in the dining room, whatever room, in the hallway. There were so many different rooms they could have been in. They could have all been in separate rooms. They all had their own room, right? They could have been in separate rooms. But I accurately discerned that there were 2 people in each room, and I accurately discerned that together they were murdered. I did say that EC was first, and then MM and KG was second and third together, and that fourth was Zana. But I said that she went to find KG and MM, and then comes to find out she ran into the murderer, and what was going on was walked down to her room, and that it happened to her. So even though XK and EC were in the same room, I don't think that they were passed away or were harmed at the same time. I also mentioned, and this is also new coming out in, this may come out in evidence as well, is that I said that EC did not immediately he wasn't like, unalived immediately, that he was harmed and succumbed to his injuries.
December 1, 2022, Guillard posted a TikTok video stating the victims KG and MM were murdered in the same room, and victims X, K, and EC were murdered in the same room. December 9, 2022, Guillard posted a TikTok video that X, K found KG and MM dead in the same room. On December 9, 2022, Guillard posted a TikTok video that JD killed EC first, KG and MM together, and Xana last. This sworn statement filed on December 29th reveals that victims KG and MM were found in the same room, and XK and EC were found deceased in the same room. Guillard's video statement regarding the quadruple homicides matches the evidence presented in the homicide case. And again, I don't know what she heard before she made those videos in terms of what was put out there.
It was not put out there. There was no legal documents put out saying the location of, not that I know of, not for outsiders. I don't know what people in Idaho knew, because apparently they knew about everything before everybody else. But again, I was in Texas, so I didn't know anything about that. So it was no public information regarding the location of the roommates nor location of the bodies.
I haven't really reviewed the police statement because it hasn't really been relevant to the civil case. I may take a look at that. On December 2nd, 2022, Guillard posted a TikTok video stating that law enforcement would announce JD as a suspect or make an arrest regarding the murder of the 4 students within 2 to 4 weeks. Okay, I don't believe she named him. She may have said that she thought they would arrest someone within 2 to 4 weeks, which was, clearly a guess, but a suspect was arrested on December 30th in exactly 4 weeks. Okay, again, what does that have to do with the defamation? The state's evidence corroborates several of Guillard's TikTok videos regarding the homicides. Guillard's Claircognizant abilities, tarot and oracle card readings, and psychic investigation skills have proven to be accurate, reliable, and plausible. Newly unsealed evidence that Gillard's videos have not proven to be false. Okay. Oh, so she means the newly evidence supports her videos? November 23rd, 2022, Gillard posted a few TikTok videos that there were two killers. Two killers? Where the freak is this coming from? In the University of Idaho murders.
I don't even think he saw my videos. He just jumped on the bandwagon to talk shit about me so he can get clicks, views, and money and likes.
December 5th, 2022, Gillard posted TikTok videos that Schofield had a choice between two male students to carry out the deaths. I don't remember that. And she ultimately chose one, not BK. On February 24, 2025. What? So she's saying the professor allegedly chose someone who wasn't the guy that actually did it? This doesn't make sense. But
he is not the guy who actually did it. He has not been proven guilty.
And Koberger, by and through his attorneys of record, filed a motion regarding inconclusive data. The motion revealed the existence of DNA evidence of 3 different people on victim MM's left fingernail that is exculpatory to BK. Well, I mean, it muddies the waters. I don't know that it's exculpatory.
See, this is what they were talking about in their motions when they asked not to admit that evidence because people would be confused. He's one of the people who are so simple. He's a nitwit, and he could be one of the jurors that's confused, even though he's not. It's exculpatory because it's not his DNA.
Let's see what she says. The Latta County coroner confirmed the existence of defensive wounds on the victim. Oh, God. Of course. Additionally, the detectives who investigated the homicides found blood at the crime scene from 2 unidentified males, exculpatory to BK. So what? They didn't find his blood? Is that what they're...
So now it's obvious he don't know what's going on. And the reason why I mentioned that there was DNA under her nails that was exculpatory to BK, and there was the coroner saying that there was existence of defensive wounds on the victims because it is possible that the DNA under her nails could come from her self-defense. And if she's defending herself and has DNA under her nails, and it is not BK's DNA, that would be exculpatory to BK. Additionally, that means the people who I accuse, and I'm not saying that it's Schofield's under her nails, but it could be their DNA.
You're saying? Like, I apologize. I really didn't go through the whole...
And to answer his dumb question, of course they did not have his blood on the scene of the crimes. What they have is touched DNA on a knife sheath, and that's skeptical as to how that got there. Very sketch.
Criminal case because it really hasn't had a lot of impact on what we've been talking about.
So, yes, it has. It's literally the whole case. And no, his blood was not there.
So I apologize that I haven't reviewed it. I'll have to take a look at it. Gillard's theory regarding the killer of the homicides is still plausible and has not been proven to be false. The state of Idaho has not revealed that they intend to identify who the unidentified DNA belongs to. Now, this doesn't really matter. It could be Joe Schmo that they discover the DNA belongs to, unless you have a direct link to the professor. All of this is just nonsense. And the police cleared, no, I shouldn't say cleared. The police stated that the professor was not a suspect, that she had nothing to do with this.
What the police, first of all, this is not nonsense, again, because it's a reason for everything. But also, what the police said is that they believe that the professor suing someone for defamation is not involved in the murders. Keyword, belief. Well, they believe she wasn't at that time. I believe she was. Guess what a belief is not? It's not evidence, and a belief is not a fact. It's not even a statement of fact. So what am I even doing here? It's a belief. So for him to, so she was not cleared, and he's right in not saying that. A lot of the times people say that she was cleared, but she wasn't. Cleared is a statement of fact, I would say. Belief is just, oh, I don't believe that. I don't believe in tarot readings. I don't believe in the plausibility of them. I don't believe my friend would do that because she likely has connections with the PD.
And the university did an investigation and discovered that the professor had no connection to any of the.
He's lying about that too. The university did not do an investigation. When I subpoenaed the University of Idaho, they said that there was no proof of an investigation. I did not, you know, of course, they had an attorney to respond. So this attorney responded in a way that they felt like was clever. There was no proof of an investigation that found documents that Schofield was connected to the students or that she taught the students. But I never said she taught the students. I said she advised the students, mentored KG. I also said, that's not necessarily through the school. A mentorship could have been through the sorority. We have mentors in our sororities. I know I have some in mine. We have advisors in our sororities. I'm sure they do too. Also, it could have just been on a basis that was less formal. It could have even been formal through the school, but I never said she taught them. I said she was a mentor, advisor. And again, University of Idaho did not do an investigation, and told me that they had no evidence of an investigation.
Victims. On January 2nd, 2023, Guillard posted TikTok videos that Kohberger was called to the scene of the crime by Rebecca Schofield, but ultimately left without committing the murders. What? Oh, so now she's trying to say that he didn't really do it and she was right about somebody else doing it. But she's just saying that the professor called him to the scene. I don't get this. On November 13th, DM testified she saw a masked man with bushy eyebrows walking towards the back door and that he walked past her but did not harm her. DM text thread also reveals a text message to BF sent between 4:22 and 24 a.m. that she saw a masked man. This text was seemingly sent before DM left her room to take refuge with BF. The state of Idaho contends that BK, the suspect, left the scene of the crime at 4:20. Gillard's theory that BK came inside the home but did not commit the homicides is still plausible and is not proven to be false. Again, you have to find direct evidence implicating the professor.
No, I don't. No, I don't. What I have to do is prove I did not make a false statement and that I did not make a false statement, or I did not make a false statement knowing that it was false. And again, this line of proving relevancy, proving accuracy, and reliability is all about plausibility. And if I'm plausible in one area and if I'm right in some of my videos, who's to say I'm not right in others, especially since no evidence has been submitted proving that anything that I said was false.
You can't, even if by some miracle she saw all of these facts that she's restating here in her visions.
Now I'm a miracle? Okay. And I never said visions. I said clear cognizance. It's a clear difference. Clear cognizance is mental. You have to use your brain. It's spiritual connection, yes, but it's also the brain. Unfortunately, I didn't just see it play out in my eyes. And I didn't get in a dream, and I do have dreams too, but I did not get it in a dream.
That doesn't link this to the professor. On December 9, 2022, Guillard posted a TikTok video that XK was crying because Ethan was injured. On December 9th, Guillard posted a few TikTok videos that DM saw victim XK alive the night of the murders, promised to get help, but chose to hide with BF to protect herself instead of seeking help. DM text message reveal she stopped texting with BF at around 4:25, likely leaving her room to hide with BF. DM made a statement to law enforcement that she heard XK crying and a male voice say something to the effect of, "It's okay, I'm going to help you." Gillard's TikTok.
And that's the reason why I'm saying that I posted that, because not only was my video accurate regarding, it matches the evidence, but also DM stated that she heard someone saying that they were promising to get XK help. Mind you, BK has already left. According to the states and their cameras and evidence that they have regarding the location of the alleged white Elantra involved, They said he left about, 4:20. DM did not leave her room until after that. And she saw XK crying after that because she had to walk past XK in order for her to get to BF and hide together. So it is likely that DM told XK when she was crying that she was going to get her some help. But instead of going to get her some help, she decided to hide. Why? Likely because she saw a masked man go outside. Or she just wanted self preservation. Maybe both. I don't think she's being honest about a male voice saying, "It's okay, I'm going to get help." I think it was actually her. And my videos discern that it was the roommates who said that they would get XK some help, but ultimately chose not to, ultimately choosing to hide instead.
Videos regarding.
But this is not to say anything bad about them, because who knows what anyone else would have done. Maybe someone else would have hid too if they saw a masked man go outside. Well, you're not going to go outside with them. Now, why they didn't call the police, that's a whole nother discussion.
XK point of view the night of the homicides is supported by evidence have not proven to be false. On January 2nd, 2023, Guillard posted a TikTok video stating, after Kohberger left the scene of the crime without killing anyone, the killer and RS considered Kohberger to be a problem to deal with later because he was a witness to their plot. On January 2nd, 2023, Guillard posted a video that Kohberger was being framed for the homicide. On March 10th, 2025, the state of Idaho revealed that the state intends to introduce evidence or testimony that law enforcement received a tip without mention of the source or substance of the tip, and that law enforcement then followed up and identified the defendant, Brian Kohberger. So I guess he called in a tip, maybe out of guilt?
No, dummy. I never said that. You can't even comprehend. I never said that BK called a tip on himself. And again, he's not following the case, or he will understand why they said that.
So I don't know. On March 10th, 2025, the state of Idaho filed a motion. On page 13 of that motion, the state infers that based on the defense's expert disclosures that the defense plans to argue that Kohberger is being framed and that the knife sheath itself could have been planted by the real perpetrator. Okay, well, that's just a theory of the defense. That doesn't mean that
this entire case is theory. Nobody has proven anything yet.
It's true. Guillard's TikTok videos regarding the framing of BK has not proven to be false. On December 13th, Guillard posted a video that Schofield does not have a valid case for defamation against her because she did not have convincing or substantial evidence that she did not kill the 4 students. Okay, and the court pointed out to her, it's not up to the professor to prove she didn't do it. It's up to Ashley Guillard to prove that what she said was true. So
yeah, that's not accurate at all. It is the plaintiff's responsibility to prove her case. It is not the defendant's responsibility to prove the plaintiff's case. It's my job for my affirmative defenses or whatever defense I have, which is that I was telling the absolute and substantial truth. And also that I was privileged. The court has denied that. The court has said that in the summary judgment, the court says, I don't want to say alleges because they said that the plaintiff introduced enough evidence that there were no issues of material fact and that they were entitled to a summary judgment against me for defamation as a matter of law. Then the burden of proof was shifted to me to prove that there are issues of material fact. I feel like there's several issues of material fact because the evidence connected to the case is under seal. And although some of it has come out already, a lot of it has not. And as time goes by, a lot of the evidence is aligning to what I've already put out. Some of the videos I've said, proving that claircognizance is plausible, proving that I am telling the truth. And a lot of the things that I said is true. So therefore, there is not malice. Proving there is issue of material fact because as more evidence comes out that I don't have access to otherwise to the public, that again, My statements are true. So, yes, I have the burden to prove it because of the summary judgment, but no, the entire case must be proven by the plaintiff because it is the plaintiff's case. Just like the state of Idaho has to prove that Kohlberger is guilty beyond a reasonable doubt, and the jury has to decide if they have proven that. And of course, the defendants have to protect themselves and provide their theories, their defenses as well.
It's backwards. Guillard stated they needed a different murderer, a thorough investigation of Schofield's connection to the murders by Moscow PD or the FBI, statement for the MPD or the FBI that Schofield isn't the killer, and proof that what Guillard is saying is false. On December 2022, an anonymous person gave the FBI a tip accusing Kohlberger of the homicides. On December 19th, the FBI gave Brett Payne of Moscow PD Kohlberger's name as a potential suspect. On December 21, 2022, Schofield filed this civil complaint against Guillard. On December 27th, MPD issued a statement. At this time in the investigation, detectives do not believe the female associate professor and chair of the history department at the University of Idaho suing a TikToker for defamation is involved in this crime. Brian Kohlberger was arrested on December 30, 2022. Based on the timing of Gillard's TikTok videos regarding Schofield's connection to the homicides, to include the fact that she had access to a white Elantra the night of the murders, the timing of the civil complaint, the timing of the anonymous tip connecting BK to the crimes, there's a possible connection between Schofield and the person who gave the anonymous tip leading to the arrest of Brian Kohlberger. But here's the thing. She's got to prove that. She can't just say, well, it's possible. Maybe it'll come out that happened. Because as of this time, there's no evidence connecting the professor.
Not only do I not have to prove I don't have to prove that. I don't have to prove a criminal offense. Not only do I not have to prove it, she doesn't even have to admit to criminal behavior because it could implicate her. That's called the Fifth Amendment. Also, this is not a criminal case. I don't have to prove that she committed a crime. What I have to prove is I did not make, and I don't have to prove, matter of fact, they have to prove that I made a false statement knowing it is false. And I have to defend myself with evidence, with whatever I can provide, that I did not make a false statement knowing that it was false. That's my argument, the truth. It is not my responsibility to make the state's case, to find evidence for the states, to find evidence of a crime. I don't have to do it. I just don't.
Professor to this in any way other than the fanciful delusions of this person.
Your mama.
State of Idaho versus Kohlberger is ongoing. Nearly all the evidence is hidden, sealed, or not made available to the public. Yes, but just because the evidence is sealed, if they thought the professor was involved as a suspect, they would have said she's a suspect, probably, or they would have arrested her. They would.
You don't know what they would have done. People who have been following this case expected much more from them. A lot of people expected much more from them and got much less. So you don't know what they would have done.
Wouldn't come out and say she's not a suspect if they've reviewed the evidence and she's implicated. So this is nothing. Defendant Ashley Guillard does not have access to the state's discovery. However, of course she doesn't, because it's a freaking criminal case. This is a civil case. However, as more information is disseminated and made available to the public, Guillard's video statements regarding the homicide align with the evidence. Coincidentally, in some aspects, maybe, Schofield has admitted that Guillard is correct. Schofield did have access to it. Okay, the fact that she had access to a white Elantra doesn't mean anything. There are a million of them out there. And
tell that to the state of Idaho.
Just because coincidentally it's the same make and model of car, there would have to be something else to lead the police to believe that this was the professor's car. And I'm guessing they must have figured out whose car it is by now. And
they have not. Don't guess.
Most likely they've decided it's not.
Do you even research before you do videos?
Not the professor's. Otherwise, again, she would be a suspect and probably be arrested. However, Schofield did have access to white Elantra the night of the homicides, nearly identical. It would have to be identical to the white Elantra MPD the murder suspect drove. But again, they must have been able to figure out what car he was driving. Guillard's absolute defense of truth against the plaintiff's defamation claims are plausible. Until the evidence regarding the homicides is made available to the public, there are issues of material fact in this case. Pursuant to the state of Idaho and the quadruple homicide case, discovery has been complicated, dynamic, and constantly evolving as new information comes to light. The state believes it serves the interests of the parties in the court for there to be reasonable flexibility to facilitate the development and exchange of relevant information to assist the trial jury. Due to the connection of the civil case of Schofield v. Guillard and the criminal case of the state of Idaho v. Brian Koberger, the same sentiment applies. It is too early for the court to rule on a summary judgment due to the complexity of the case. It is in the best interest of justice, the party, and the court that for there to be reasonable flexibility to allow for the development and exchange of relevant information and evidence to assist the trial jury. Okay, but again, she's not a suspect. Not at all. She has no demonstrable connection to any of the victims or the killer.
He does not know that. He is just chatting. There has been no evidence to suggest that. It's only been her word.
So she's really just relying on the fact that the professor had a similar car to the one driven by the murderer. That's not enough evidence to make her a suspect. Because, like I said, they must know what vehicle he was driving.
No, they don't. They know the make and model of a vehicle. They don't have registration. They don't have tags. You would know that if you did your research.
Otherwise, they would have investigated further. Conclusion of prayer for relief, the court has erroneously placed the burden of proof to prove Schofield caused the murder on the defendant. No, that's the way it works. You have to prove that what you said is true. She doesn't have to.
That's not how the law works. And for you to be a lawyer, this is absolutely horrifying for you to be saying such ignorant statements. It is the plaintiff's job to prove her case.
Prove that what you said is false.
She has to prove that I made a false statement, knowing that it was false, that she has damages, actual damages, that I made a statement anyway, and that she was involved in a statement. She has to prove the elements. She does.
It's the way it works in a defamation trial. However, the evidence regarding the 4 homicides is controlled by the state, is largely sealed and redacted. Hence, there are issues of material fact of the case. As evidence regarding the events that took place the night of the murders is made public, Guillard's TikTok videos are consistently proving to be the absolute truth and substantially true. Okay, they're either the absolute truth or
it's multiple videos. They're both. Some may be absolutely true. Some may be substantially true. Okay?
Substantially true. They can't be both. Beyond the parameters of a coincidence. Therefore, if it is Guillard's burden to prove that Schofield was involved, it is reasonable for the court to wait until after the evidence is made available to the public before any judge or jury can make any decisions on the merits of the case. Guillard's consistent accuracy proves that her videos were not published with malice. Additionally, because evidence supports the accuracy of her claircognizant abilities, she is reasonable to believe that she's capable of getting the truth of the matter. I guess better than the police. Plaintiff Rebecca Schofield has made...
And that has been proven. Because even when the police were making statements that were not true, the statements that I was making during that time and before and after. The statements I made were true. The statements the police made public and published in a press release were not, i.e. the roommates. So, yes.
Several false statements about Ashley Guillard has not made false statements knowing they are false. Well, if she doesn't know the evidence and she doesn't know the facts, then she is making statements that she can't possibly know are true because
I heard something. Again, that's not the law. The law is to make a statement knowing that it is false. The defamation law is not making a statement without evidence to back your statement. Because if evidence was required for us to even speak anything, there would be so many defamation cases. If we had to walk around with evidence and we could not make a statement without evidence, or otherwise it is proven that we're saying something that we don't believe to be true, everybody would be sued for defamation. Okay, it is, and more people should be sued for defamation, but that would be crazy. The law is making a false statement knowing it is false, not making a statement without evidence. That's not the law.
She doesn't have the evidence to back it up. In fact, many of Guillard's statements are backed by evidence and absolutely true. So again, are they substantial?
And it turns out that the statements that I made are backed by evidence. But that does not mean the law requires that my statements are backed by evidence. The law requires to win on a defamation that a person makes a false statement intentionally, meaning they make a false statement and they know that that statement that they made is false.
Substantially true or absolutely true. Additionally, Schofield is not provided by the preponderance of the evidence that Guillard defamed her. It is in the best interest of justice that the order granting partial summary judgment is completely reversed. Defendant Ashley Guillard moves the court to deny the plaintiff's motion for partial summary judgment and deny the plaintiff's motion for leave to amend the complaint to add punitive damages. This is so crazy.
No,
it's like she's grasping at straws here. Again, they've reviewed the evidence. It's not like there's more evidence coming from the crime scene.
is he serious? What? There is way more evidence and it's been hidden.
This has been a while now. It's been what?
Yes, it has been a while. And they are just now releasing just a tad bit of evidence.
Over 2 years. So it's been several years now. Any evidence that they needed to gather, I'm sure they've gotten.
Again, you're not watching the trial. It's been so much evidence that even the defense, Kohlberger's defense, has not seen it all.
I can't believe that some Perry Mason moment is going to happen now.
I don't care what you believe.
Where it's going to be revealed that the professor is involved. There are no connections at all.
You don't know that.
There's none that have been found. It's been stated by the police that she's not involved. It's been stated by...
The police said a lot. And come to find out, wasn't true.
The university that they investigated that she had...
They did not investigate.
Had no connection. This is all just nonsense. But she's clinging...
Yes, everything you said was nonsense.
Clinging to the mast as the ship goes down, hoping that the court will somehow now, this umpteenth time...
Yes, I'm going to defend myself even when the court is not being fair and not making sound judgments based on the law.
Change their mind based on nothing that I see as evidence that the professor is involved. Let me know what you think down in the comments below. The ongoing saga.
I think you're an idiot.
Of the TikTok psychic. I appreciate you guys being here. I want to thank...
All right. Oh my goodness. So I'm just going to leave it there. Thank you for watching. Peace.